speaking with me, Tarun Nangia. Today, we are going to discuss a very, very interesting concept. Can small disputes involving small amounts, say up to 10, 12 lakh rupees, and small causes, can they be mandatorily arbitrated? Can such a direction be issued by the court that it is ensured that these small matters are arbitrated and settled at a certain limited fee so that people are also able to pay? But the main agenda here is that the burden on our judiciary is lightened a bit. We have well-meaning lawyers and well-meaning judges, including Chief Justice of India, Justice N.V. Ramana, who has said that he is keen to push arbitration. And he's not said this once, but I can count on many occasions he has said it. Most recently, after the inauguration of the Hyderabad International Arbitration and Mediation Center. Arbitration will truly be a success in India if it is not limited to large matters involving thousands of crores or hundreds of crores, but even mediation and arbitration will be successful if a lot of day-to-day matters, smaller matters can get settled. This idea came to me in an interaction with Vivek Mittal. He's Global General Counsel of Dr. Reddy's. He joins us today on the show. So let me welcome Mr. Vivek Mittal for the first time on Legally Speaking. Welcome and looking forward to your interventions on the show, Vivek.
Pleasure to be here, Tarun, and good to interact with this august people here.
May I also welcome Justice Iqbal Ahmed Ansari, former Chief Justice of the Patna High Court, on the show. We look forward to his comments on inputs by our panelists. May I welcome Senior Advocate Arvind Nair, a very familiar face at the NCLT, Delhi High Court and Supreme Court in the national capital. Welcome, Arvind, on the show today. I also welcome Advocate Abhimanyu Bhandari on the show, an advocate practicing at the Delhi High Court and Supreme Court. Shashank Garg also has a keen interest in arbitration, also is a lawyer at the Delhi High Court and Supreme Court. And let us begin. First, if I may request Vivek Mittal, say in about next 2.5, 3 minutes, if you could lay the ground of the show by putting out your idea, which you thought will be good. And then we will begin by comments from the panelists before we go to Justice Ansari. Vivek, the floor is for you.
Thank you, Tarun. So the idea which I discussed with you, Tarun, came to me when I was at Hyderabad International Arbitration Center curtain raiser, and I was one of the panel there. So we were trying to debate that how can we make this arbitration a better process. So one of the ideas which came to my mind is that why don't we make this arbitration or ADR process, I would say, make it reach to masses. I think India is country of masses, and everything becomes very successful when it reaches to masses. So the basic idea which I was suggesting is that why not we by law actually adjudicate small matters, let's say small fines or small billing disputes or small employment matters or small Factories Act related kind of matters where fine is very minimal through ADR process. So I would not use the term arbitration intentionally, because when we talk about ADR, the host of activities actually happens there. So arbitration, mediation, conciliation, summary proceedings. I would also want to include paper-only adjudication there, because there are many countries who are actually moving towards paper-only adjudication process where parties would submit their papers and the matters would be adjudicated. So the idea is that in India, every small matter would go to court. And many times the lawyers involved would not have access to or would not want parties to go to ADR process because of various reasons. So small matters will also go to courts, and that increases courts' burden. My idea is that why not we actually shift all these matters to ADR process. This ADR process could be, and this is just I've envisaged that ADR process could be catalog-based ADR process, where people say if the matter is between 0 to 5,000 rupees, then probably you'll have to pay 100,000 rupees and your matter will get resolved. Then 5,000 to 25,000, 25,000 to 1 lakh. I'm just saying that there could be slabs and there could be a predictable fee. This also will help in a lot of ways in reducing the court burden and also make justice reach to masses. In my own experience, I can tell you that many times people don't go to court processes because they think court process is very lengthy, that will take years. It also the court process also has this element of, people don't know that how much money they will have to spend. Through this ADR process of small matters, the outcome will be visible, cost will be transparent, and people will get justice. So by this way, we can achieve a lot of things. We can reduce courts burden. We can make justice reach to masses. The small matters will get resolved very, very fast instead of dragging number of years. And also, people will be happy. There could be many innovative ways around it which we can build in. Maybe we can only say the losing party will pay the fee. We can bring in discovery kind of process, very small discovery kind of process in these matters. We can also think through, document-only proceedings. We can also bring in SMEs, a lot of SMEs into this process. Right now, only lawyers actually go and judges actually adjudicate the matter. We can certainly bring in SMEs in this entire process. We can also bring in retired talent. So what I want to say is that make this process much more efficient and make it reach to masses, and at the same time reduce courts burden, so that we become a very, very progressive company. I think there's a lot of need of innovation in this specific sector. And that's the thought process I bring to the table. I also want to tell you that the way I look at it, in the way this aggregation model is happening across industry, I have not seen any specific innovation in this judicial process because of its own reasons. And I am a lawyer and I support it, that this process cannot be completely innovated, but there should be more innovation so that we can achieve all of these, what I suggested. So this is the thought process I have, and hence I reached out to you and you reached out to me and we talked about it.
Thank you so much, Mr. Vivek Mittal, for sharing this view. I'll go to Senior Advocate Arvind Nair at this point of view. Mr. Nair, you represent the court in some of the high-profile matters involving thousands of crores in dispute. The court will equally give time to each case. But do you think that the idea that Vivek is propounding will, in a sense, reduce the court's burden and ensure that a lot of matters involving larger sums and lot of, in a sense, beneficiaries or people who are in contention, it will be beneficial? How would somebody like you with so many years of practice look at this idea?
I think it's a very welcome idea. Vivek used the word masses. Let me just respond to it in three ways: A, B, and C. A is that, we have a retired Chief Justice here who will also enlighten us more on this. Even in normal times, the burden on our courts, on our honorable courts, is humongous. The weight of numbers it makes it very difficult for the honorable courts and the judges to take up every single matter. And it doesn't matter, you used a term, a numerical term, whether it's 1,000 crores or whether it's 100 rupees. Anybody who goes to court expects that he will get judicial time, he will get application of judicial mind. So everybody from that perspective is on the same level. So now with the pandemic, what is going to happen is that this docket explosion, which we are looking at, is going to happen. And we are already looking at it. Every court perhaps has 50, 70, 100 cases on a day. There are 2021 lists, there are 2020 lists, so on and so forth. So one is to make sure that masses get their justice faster. We must have this kind of mechanism. Number two, I am reminded of the time when the Lok Adalat system began. It began like this, because what had happened was, and the initiative perhaps came from, if I remember correctly, came from the honorable judges also, interaction between honorable judges and members of the bar. Because every little dispute, whether it was pertaining to an electricity bill that was higher than expected, whether it was related to a water connection, whether it was a small difference or miscommunication between two neighbors over parking rights in a common space, all of those issues have now started getting resolved through Lok Adalats. In fact, the number of cases that are resolved in a 2-day or 4-day sitting of a Lok Adalat is staggering. Sometimes it runs into lakhs. So that is the second aspect of the matter. The third is small and micro enterprises is a word which Vivek used. We do have this mechanism under the MSME Act that within 90 days, if there is a reference, there is a facilitation council which will first do conciliation and then will refer the matter to arbitration either by themselves or by referring it to another center. Now we have centers also. There is the Hyderabad center. There are other centers coming. So time is ripe. And I think for a lot of people who sometimes don't go to court because they feel that the time that they're going to spend till the case is finally decided is something that they can't reconcile with, that worry can be taken care of. So I think we are perhaps, this idea is coming at absolutely the right time. This is the need of the hour.
Thank you so much, Senior Advocate Arvind Nair, for your endorsement of this idea. And also shows that well-meaning counsels like you think beyond, in a sense, their own matters, to think of more good of the judicial system, because it involves all of us. Not only Chief Justice of India, Justice Ramana, but lawyers are also thinking. Vivek Mittal came up with the idea. I'll go to Advocate Abhimanyu Bhandari. We saw that our Chief Justice, present Chief Justice, has been very vocal about pushing arbitration. And not only arbitration, mediation, basically ADR. So in his vision, he understands that the court system alone cannot handle the crushing load of cases under which the judiciary is currently, in a sense, facing on a day-to-day basis. Taking that angle, what would you like to comment on the idea given by Vivek Mittal?
Thank you, Tarun. I think the idea given by Vivek Mittal is very good, and I think it is the need of the hour. And I was actually thinking when I heard Senior Advocate Arvind Nair and I heard Mr. Vivek Mittal with all these, that we could, try to get a statutory mechanism in. I think first we must understand, as Mr. Nair rightly said, that under the MSMED Act, there is already a structure where there's a facilitation center that then leads to an arbitration. You would be surprised to know, Tarun, that other than the MSMED Act, there are a large number of other local acts in various states which provide for this alternative dispute resolution. For example, there is the MP Madhyastham Adhikaran Adhiniyam Act of 1983, which says any of the dispute with the state, any contractor that can have, under that act can go and initiate arbitration, and there's a time-bound arbitration process. So there is a lot of legislative instruments all around which provide for various structures. However, each of them have their own pitfalls. Each of them have their own issues. You see, when we talk about a case, Tarun, whether you have 1,000 crore claim against someone or you have a 10 rupees claim against someone, law doesn't differentiate between the amount of the claim. Both the claimants and both the defendants have to go through the process of law, and they have to go through the process of civil procedure code or civil process, where everyone has a right to cross-examine. Everyone would have a right to lead evidence. Everyone would have a right to discovery and production of documents, and of course, pleadings. So whether it's a big case or a small case in a numerical way, everyone has a particular right to go through the adjudication. Now, we in our country have come out with a very innovative solution to this in the form of the Consumer Protection Act. And I think if we really are sincere in providing what Vivek Mittal is going at, we need to provide a forum like that. Consumer Protection Act, every consumer, whether he bought a Coca-Cola from the Coca-Cola shop or whether he hired a Tata's to buy him a car, any consumer did not have to go and file a civil court in a court of law if he felt that the service or the goods that he got was inadequate for what he paid. And in a summary trial, in a way, people got their relief. If you know, a large number of home buyers got their relief from builders. A large number of people who had bought a mechanically defective goods got money returned from this thing. But however, there is a limitation in the Consumer Act, whereby the Consumer Act only applies to personal goods and services. So if you're a consumer of goods and services, it won't apply to a contractor who is spent, whose bill is a 10 lakh rupee meager bill to do a particular work for a particular company. What we could do is that we could increase the number of consumer forums, because remember, the structure is very holistic. There is a national consumer forum, there is the state consumer forum, there is a district consumer forum. We could actually have more consumer forums and more judicial minds sitting in consumer forums. And we could tweak the definition to also include commercial disputes up to a particular value. And I think that would really, really help in providing this alternative structure. Because remember, at one end, whether it's a 10 rupee dispute or a 10,000 crore dispute, every litigant has a right to be heard properly and that his case is decided as per law, not just in some random arbitrary mechanism. So we need good judicial trained minds. And we need a forum where anybody can go, because for someone 10 rupees may be a lot of money, and for someone 10 rupees may be a very petty amount. But everybody feels that, they should get the right to kind of adjudicate in a particular fashion.
Point.
So one way to address the concern that Mr. Mittal has raised in this show would be to use the existing statutory mechanisms that we have in our country and, populate them with more judicial minds so that more people can access it quickly.
Point very well taken, Abhimanyu. And I would like to highlight one point before I go to Advocate Shashank Garg. The idea which I understood when I discussed it with Mr. Vivek Mittal is that, take for example, the Delhi High Court. We have only half the number of required judges. Now, should they be, in a sense, engaging their time on matters which could have well been settled by ADR long ago? Because sometimes even small disputes find their way to the High Court. Or should we, in a sense, manage them and settle them at the lower level itself? Advocate Shashank Garg, you've been a great votary of arbitration. And whenever you have spoken, you've been pro-ADR, pro-arbitration. Now we take this whole process into a different domain of small disputes. Do you think this idea has it in it to be successful, especially at a time when the judiciary and the top most level in the judiciary at the Chief Justice level is wanting to push it? Do you think this is doable?
Thank you, Tarun. Tarun, I think I would join my co-panelists in agreeing that it's a novel idea, but I must also highlight that enough has been done in the recent past working on this mechanism. Abhimanyu pointed out, Mr. Nair also pointed out, whether you take example of consumer redressal, whether you take example of MSME Act, or look at even the IBC now and Commercial Courts Act, which mandates pre-suit mediation. I think a lot of steps in this regard have been taken where the smaller disputes or disputes which can easily be adjudicated through ADR mechanism should be sent to an ADR mechanism. Now, taking this idea a little ahead, see, if you mandate mediation, we have seen that mediation, mandatory mediation may ultimately result with no settlement whatsoever, because the way mediation is designed, the mediator has a very limited role. And if the parties are hell-bent on adjudication, it's very unlikely that their emotional satisfaction may not come out from a mediation. So let us look at arbitration in particular and put that idea together with arbitration. See, if we look at arbitration in smaller disputes, the real concern emerges of the cost. That is where I think some sort of a progressive decision has to be taken at the highest level. And also all of us stakeholders, councils in the industry, judges, as a matter of service to the society, should take an oath to do at least some of these matters as an arbitrator for smaller disputes where they actually do not wish to charge any fee, or whatever fee is being charged is either sent to a charity or any organization that can benefit out of it. I'll give you one example. A matter was in court assigned to me in Section 11, where the judge told me to charge a specific amount of fee, which was a very low fee. It was a very small dispute. And I took up that matter and I ordered the parties to deposit that cost. There was a flood in Kerala, so to the CM Relief Fund of Kerala. So some of these kind of innovative mechanisms can be adopted, and all of us, I think, have certain duty towards a society where even in commercial arbitration, we should make it affordable. What Abhimanyu pointed out, there is a fee schedule. Even if it is a dispute of 100 rupees and somebody wants to invoke arbitration, he will not be stopped by the law. He may have difficulty finding an arbitrator. He may have difficulty finding a good mind to put his time behind it. So I think on that, if there is a decision that is taken at the highest level and all of us as stakeholders also agree to contribute some time towards smaller disputes, it would be a great service in reduction of the pendency that we see before courts. And also we all advocate this from time to time that all of us should do some pro bono work. So this could be one of the parts of that pro bono work that all of us should take up.
Shashank, one feels happy that someone like you, it seems like everybody is pulling in. The judges have been pro-arbitration, lawyers like you have been pulling in this, so that, when we still can't match up, we are not filling up vacancies at the level that they should have been. It's somehow not possible. I think this can free up a lot of load from the judiciary in the post-pandemic times when I think pendency has become exponential. We'll take a short break and we'll go to Justice Ansari right after the break. Welcome back. Just before the break, we saw Advocate Shashank Garg giving in his views. Let me take this to Justice Ansari. Sir, if you could share your comments on the views made by the panelists and the idea proposed by Mr. Mittal.
The idea propounded by Mr. Mittal and more or less supported by all the panelists is a welcome step, no doubt about it. But we have to be very clear. Are we talking only about arbitration, or are we talking about arbitration, mediation, conciliation, all the alternative dispute resolution? Now, as far as small arbitrations are concerned, small in the sense of amount of money involved is concerned, then in that event, the number of arbitration will increase, no doubt about it, but it will help in the reduction of the cases, pending cases in the court. It's a very good idea because even civil procedure court envisages a small causes court. It's not that it cannot be done, it should be done if it is feasible. Only thing is that as far as the consumer fora are concerned, that will be slightly difficult because consumer forums are already overburdened, and if you put more cases without changing any kind of infrastructural change, then it will be adding to the same in structure, and thereby loading the forum with a greater number of cases, and that may perhaps defeat the very purpose for which we are all propagating formation of the taking of steps for arbitration. Arbitration, as a matter of fact, needs consent of both the sides, but we can make a compulsory arbitration that up to this amount there must be an effort to make arbitration. And I have a feeling, you can call it instinct, very strong, that if the arbitration are in the smaller matters are taken up on urgent basis, it will yield very good result.
Okay. Thanks for that input. Vivek Mittal wants to join in. Mr. Mittal.
Yeah. So I heard everyone, including Justice Ansari. Especially, I want to respond to Abhimanyu and Shashank. While I do appreciate that there are still a lot happening in this area, let's say Consumer Court was given example, or MSME Act has been given example. I can only say that those are not yielding results. So just to take example of consumer courts, I think process still takes a lot of time. If you go to consumer court process, you have to go to district, state, national. The process remains the same, but they are specialized courts. What I'm trying to suggest is, why don't we think completely out of box, as suggested by Justice Ansari, and as I'm endorsing, that small matters of certain amount should mandatorily go to ADR process. We can also look at paper-only trial. We can also look at some other ideas which are floating around the world. So when I was reading about it, rent a judge. While this doesn't sound good, rent a judge, but in US there is a concept of rent a judge. You actually hire a person. This is similar to arbitration process. Take him to one place where parties will actually complete their proceedings in one go, and that's the part of process, that you have to complete proceedings in one go. So what I'm trying to say is, we need to be a little more innovative than think within the boundaries of law. While we need to be process-wise, we need to be within the boundaries of law, but we need to think out of box so that we achieve the process of giving justice to people, but at the same time achieve the speed and reduce the burden. Okay. That's what I'm advocating for.
Now, thanks for that input. Now we're beginning Justice Ansari, and then I'll go to Senior Advocate Arvind Nair.
To shorten the time frame which is required for the purpose of disposal of arbitration matter, I think we need to encourage the lawyers are appearing in these cases to go for interrogatories. That will reduce the time frame. The second way is for the admission and denial, which will again reduce. So we will be left with very little evidence, if at all necessary. Otherwise, most of the thing, either at the admission or denial stage, it will be over, or with the help of the interrogatories, the answers would be available before us.
Point well taken. Senior Advocate Arvind Nair, from your experience, I would like to understand, is it possible that certain arbitration centers are dedicated for this purpose, that a certain kind of cases will be arbitrated at that center, so they are even accessible online? Do you think such a thing is possible in today's world? Can a certain center be dedicated for small cases, that this is the forum where you go and these things can be settled?
Absolutely, Tarun. I think just like we used to have, and some jurisdictions still have a small causes court, and we have separate forums, there is no reason, with the way technology has now advanced and with the way we have all learned to, the online mode, the virtual mode, there is no reason why we should not have exclusively dedicated centers for these kind of arbitrations. But having said that, what we need to look at it is that we'll have to structure this system. And the two most important factors of that structuring will be costs. As my colleague said, you'll have to have a capping of the costs. And the other is strict enforcement of timelines. I think here a very important learning process for us, for all of us who are now advocating this system, could be the mediation process. Because the mediation process actually began with very active input from honorable judges. So we can see what has worked, what have been positives in the mediation process, what have been negatives. Then we come to the third aspect, which is whether we improve the existing system or we come up with something totally new from the ground level up. And I think what we need to see, if we are talking of mandatory referral to arbitrations, then we need to learn from the experiences of other jurisdictions. For instance, in Europe, I'm told, there is a lot of resistance to mandatory arbitration. In the United States also, it's been a little different. There has been a judgment called CompuCredit versus Greenwood, where the bar has been kept very high by the United States Supreme Court. So I think it's a very noble idea. It's idealistic. It's the way forward, and it's absolutely and totally workable. But we will need to learn from some of the processes that are already in place and ensure that we avoid the usual pitfalls, the regular usual pitfalls.
Okay, point well taken. Abhimanyu, your closing comment?
My closing comment is that we need to now provide a proper institutional mechanism to this whole thing if it has to be a success. It cannot be ad hoc, and there cannot be a number of legislation overlapping with each other. So really, to make this system work, we need a proper act with detailed rules and a full structure to make it happen. And it's extremely important that we do this very quickly, because now with the new IBC code, if a small company's debt, he cannot recover his money quickly, then he cannot meet his other cash flows, and he can be immediately put into insolvency. So therefore, for small companies, for small claims also, it's extremely important that they should be able to recover their amounts from their counterparties very quickly. And therefore, we do need a very, very robust system and a good, robust ADR system. And I stick to what I had said earlier, is that we need to use some institution which is already there and populate it more and expand its jurisdiction, probably like the Consumer Forum.
Thanks for sharing that view. Advocate Shashankar, your closing comment.
See, from what I've heard from everybody, I think a mixed model can work really well, where private players, of course, would not really be interested in setting up an institution and do the small causes arbitration. They're, of course, looking for big money. But if it is institutionalized by the government, by the state governments, or by the central government, or by the judiciary, whichever stakeholder wants to take responsibility of it, and you appoint people who would be adjudicators, you want to rename the system, don't call it arbitration, as it was being pointed out, that there can be resistance from lawyers, call it mandatory adjudication, or whatever you want to call it, and empanel people, give them honorarium for what they are doing, just like in mediation we are doing so. In mediation, the parties are not paying anything in Samadhan if they are able to successfully, get to a settlement. And the mediators are paid an honorarium by the government. So similarly, a mixed model wherein you have people empaneled, you give them the honorarium that should come from either the state government or the central government or the judiciary. Let them adjudicate whether they follow the mediation, negotiation, or arbitration mechanism. That's completely something which, as Abhimanyu pointed out, a specific statute has to be, brought in place for small causes arbitration or small causes adjudication act or something like that. I think it is doable, but it will have to, as I was trying to say, you have to pick up good things from each of these systems and fix them together for this to really work and yield results.
Thanks so much, Shashank, for that view. So as I said, ideation is an important process for, in a sense, something to come up in reality. Justice N.V. Ramanna ideated, and look, we have the Hyderabad International Arbitration and Mediation Center. Many times we have discussed the issue of arbitration on this show, involving, of course, high-profile arbitration involving much larger amounts. But first, also as a process of ideation at Legally Speaking, idea came in from somebody like Vivek Mittal. We took this up. We wouldn't know if anything really happens tomorrow immediately, but they say an idea, the most powerful weapon in the world is an idea, because an idea, if take roots, gets to be very far. I would like to thank all of you, each one of you, who took out time for brainstorming on this idea. And I'm sure something will come out of this. Maybe if not in this exact form, some form. There are a lot of people viewing the show. They will themselves give their additions. And we hope to see something which will ensure that these small disputes are settled off as quickly as possible. And our honorable judges get time to focus on the large matters that involve a large number of stakeholders. In some cases, many employees, in some cases, big payments, all of that require a lot of work in terms of law also. But thank you so much, all of you, for joining me today. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.